Well, there you have it. Big news, Jamie, right here on Court TV Live. Tomorrow, we are going to hear from the defendant, Lynlee Renick. I tell you, Jamie, I was of the mind that it would not be a good idea for a number of reasons. I want to get your thoughts.
I would not put her on the stand to save my own life.
Exactly.
I'm joking, but this is a serious matter. And, the judge just sort of stroked on, the important thing, and that is that this is her right. This is the one decision that defendants have unilateral control over. With that said, we're attorneys at law, we're also counselors at law, and it's the responsibility of counsel to explain the pitfalls of her going forward on the stand. And I'll have to be honest with you, Michael. I would never speak ill of another lawyer, and I'm certainly not doing it now. But based on what we just seen over the last hour, I have to come to some conclusion that the defense is not maybe as prepared as they should be. Most of this testimony should have been presented in some sort of motions prior to a jury being seated, as opposed to dealing with all this at the ninth hour. I mean, I don't know what her strategy is at this point. And with that said, my point is, it concerns me based on what I just seen as to whether or not this defendant's been properly counseled. But we've been seeing this all over the country for the last few days, and I guess we're going to see it again tomorrow. I hope it works out for her, I suppose.
Yeah, it's an interesting trend, Jamie, that a lot of defendants are now taking the stand. I don't know if this just is sort of just a small microcosm of what might be going on around the rest of the country, but here on Court TV, we're seeing a lot of defendants decide to take the stand. But I want to dig a little deeper into what you just said. Can you explain a little bit more about what you saw during that proffer of evidence that concerns you and makes you think that perhaps the defense is not as prepared as they should be?
Well, I think the concerning thing is that, there clearly were evidentiary issues. I think on the technicals, the judge probably got this right. I suggest that maybe a little leeway was appropriate in this case. I think maybe some of the evidence could have been offered, based on the potential penalties in this case. But he made the decision that none of it, that all of it was hearsay, and ultimately none of it was relevant. And I guess the point I wanted to make is that these are obvious evidentiary issues to a trial lawyer. And, how is she prepared for trial with 7 witnesses, I believe, that now cannot be included? It's just kind of a little mind-boggling to me. And, at this point, I suspect that all she has left is the defendant. And, some of this could have been worked through. And, the issue as far as Mr. Blackwell is concerned, and I think you spoke on this in your opening, there was an opportunity to challenge, this right to against self-incrimination as it applies to Mr. Blackwell, and she declined. And, that would have been an opportunity, even if the judge ruled against her and said, no, we're not even going to go there. He says he can't testify due to the Fifth, even though so many of these things that she tried to get in today were not self-incriminating in a criminal way. They were just statements that he made. She missed an opportunity because at a minimum, Michael, she probably could have asked for a curing instruction to the jury so that they would know that, Mr. Blackwell was here, he refused to cooperate. And then in her closing, she could have really gone off on the deep end on that issue, and she forfeited that. And I think that that's unfortunate for the defendant.
I have to think, Jamie, because I agree with you 100%, I have to think that there's something about Brandon Blackwell that they didn't want, or if he was going to take the Fifth, I'm not sure why it would matter. But at the very least, had they allowed him to go up there and take the Fifth and didn't challenge that, perhaps the judge might have taken the approach you're talking about, because that's the approach that I would expect under the circumstances where you have this type of murder case, a first-degree murder case. Judges do tend to give a little bit more leeway in what they allow defendants to do because the stakes are so high. And if once you introduce his name into the court, then some of these other statements make more sense. But up to this point, this jury hasn't even heard the name Brandon Blackwell. So now, in the 11th hour, to try to get these witnesses in to talk about some of the things he said and done, there's really no other way for the judge to go.
Yeah, I agree. Again, I'm not speaking ill of brethren lawyer. I just think that this may have been a mistake, and time will tell. At a minimum, I think again, this can frustrate courts, but I have on occasion when I've ran into similar situations, you make them say it for every single question, right, and get something on the record, so at least there's an appellate review as to whether or not a claim of Fifth Amendment protections was appropriate. And that's been forfeited at this point, it appears.
Yeah, and you know, that's going to be a big question surrounding this trial. Why didn't they do that? All right, so as you guys heard, Jamie, stand by. We're going to take a break now, but as you guys heard, tomorrow, Lynlee Renick will be taking the stand.